So obviously the laws regarding marijuana are changing,
Yes, they
and
are.
while it's becoming increasingly available for people to use legally, have all the laws caught up with? It seems to me they haven't. And can you think of any examples where the other laws on the books haven't caught up with marijuana becoming legal in some fashion?
There is certainly an inconsistency right now on marijuana policy. I'm reminded of on Interstate 83, there's now a billboard advertising legal Maryland sales to Pennsylvania residents, which, while the sales are legal, bringing it back to the Commonwealth is not legal.
Well, what if someone has but can use it legally in Pennsylvania? They get their validly issued medical marijuana card. So I smoke it, I use it on a day, and then the next day, 2 days later, they go out and drive their car. They're not under the influence.
Right.
Can they still be prosecuted for DUI?
Absolutely.
Why is that? I mean, they're not intoxicated. They're not high at the time.
And that's generally the original purpose behind the DUI laws. And this is one situation where that purpose has essentially gone out the window because the way the DUI statute reads, you can have, whether it's active THC in your system or the metabolite of THC in your system, if you're operating a vehicle, you are guilty of DUI.
And so, how would the law have to change?
Well, there's a bill in the General Assembly to say that if you have a medical card, they would then have to prove actual impairment. The presence of metabolite would not be enough under that circumstance.
And if the Federal Drug Administration in Washington reschedules marijuana from Schedule 1 to Schedule 3, will that fix Pennsylvania's DUI
Not
statute?
directly. There would have to be a bill from the legislature to allow either for prescriptions rather than the current recommendation, which that whole system was designed to circumvent prior laws and ethical concerns of doctors. It would have to change to make it a prescription, or change to say the mere presence of a Schedule 3 metabolite does not make you guilty of DUI. So either one of those changes would have that effect.
Something that comes up a lot is people are enthusiastic about the firearms. They like to use firearms for shooting purposes, for self-protection, and they apply for a concealed carry permit. If I have a medical marijuana card, does the law say absolutely I can't have a concealed carry permit?
Many interpret it that way, but the enforcement has been inconsistent from county to county.
Okay.
Because the law says you cannot be an habitual user or addicted to a controlled substance or an habitual drunkard, that having a medical marijuana card is regarded by some county sheriffs as per se evidence that you are an habitual user of a controlled substance and would deny or revoke a carry permit.
So it depends on the county sheriff.
The enforcement has varied, yes, because the law is not entirely clear.
Okay.
Because it doesn't specify the medical marijuana card.
Right. This law completely predates that, so it's kind of a square peg in a round hole to pass this new law.
Another occasion where the laws on the books in some fashion haven't caught up with the changes in other areas.
And I believe there's language in that statute that talks about unlawfully doing so.
Correct, meaning a prescribed substance taken as prescribed is not grounds to deny somebody a carry permit, even if the prescribed substance is something like Ritalin or Adderall that falls on Schedule 2. The issue I'm dealing with is the rescheduling and effect on the federal guidelines.
Okay.
Because the federal guidelines say marijuana is this level based on weight, but then it generically says Schedule 3 maxes out at this level, which is much lower. So there's going to be a period of at least a year where the DEA reschedules, most likely, to Schedule 3, but then the guidelines are not updated. They will just say marijuana, Schedule 1, Schedule 3.
So if marijuana gets rescheduled and you have a client facing criminal charges, are you saying, in federal court, are you saying that the potential penalties may go down?
Not the potential penalties, but the likely sentencing guideline range within the minimum and maximum.
And that's the recommended range
Correct.
the judge is supposed to use.
Correct. I'm dealing with that issue now where I've said it will be Schedule 3 by time of sentencing, most likely, so treat it as Schedule 3 under the present guidelines, even though there's a marijuana guideline.
What if the person has been sentenced and convicted already? But is now serving that sentence? do they now have grounds to go back into court and say, hey, there's been a change in the guidelines, therefore you should reconsider the sentence you imposed?
My expectation is that many will try to do that, but ultimately that would require Congress's approval to make it retroactive. The DEA can't do that on its own.